Hello and welcome to ARM Quarterly Review, What's Next for 2015. Before we begin, I'd like to thank you for attending. We know you're all busy and your time is valuable, so thank you for taking time out of your day to attend our webinar. I am Rozanne Andersen and I am the Events Specialist here at Ontario Systems, and I will be your meeting manager today. Some of you may notice over in the chat box we've left a message for you. We are having some inclement weather here in Muncie, so if things should get a little worse and we lose connectivity, please know we will work as hard as we can to reconnect on that. A few housekeeping items before we begin. First, I have some legalese that I need to read through, so it's on the record. Please bear with me or read along on the slides that should be showing on your screen. This information is not intended as legal or business advice and may not be used as such. Legal and business advice must be tailored to the specific circumstances of each case. Every effort has been made to assure this information is up to date as of the date of this presentation. It is not intended to be a full and exhaustive explanation of the law in any area, nor may you use the information to replace the advice of your own legal counsel. The presenters, Ginsberg and Ontario Systems, assume no liability for typographical or other errors contained in the presentation and materials, or for changes in the law affecting anything discussed therein. Second, since this question comes up a lot, know that we will be sending a link to the recording of this webinar in the next few weeks. If you have a question for any of our panelists, please use the questions box and we will answer them as time permits. If a question is not answered, please know we will follow up after the webinar via email. If you experience any difficulty during the presentation, please send a chat message to me and I will address it as quickly as possible. To kick things off, I'd like to share a bit about our presenters today. Mike Ginsberg is President and CEO of Ginsberg, providing industry-leading M&A and strategic advisory expertise to the ARM industry for more than 20 years. Clients served include domestic UC and international collection agencies and ARM companies, financial investors, as well as Fortune 500 companies. He is a member of ACA International, DBA, and the Association for Corporate Growth, and sits on the advisory boards of several industry associations and publications. Mike is a frequent speaker on important industry issues and is often interviewed as an industry expert by the trade, financial, and consumer media. He has also been recognized by the Collection Advisor, a leading trade publication, as one of the industry's most influential professionals for 4 years in a row. Rozanne Andersen currently serves as Vice President and Chief Compliance Officer at Ontario Systems. Her 14-plus years of experience as General Counsel, Chief Lobbyist, Executive Vice President, and CEO of ACA International, and as a practicing attorney specializing in banking and financial services, have made Rozanne one of the most respected experts in the industry. Known as a frequent presenter and consultant on all CFPB-related compliance topics, Rozanne brings both legal and a technology perspective to the ARM and healthcare industry's most serious compliance challenges. In 2014, Andersen was placed on the shortlist for 2 international compliance awards, Chief Compliance Officer of the Year and the Lifetime Achievement Award for services to the compliance industry. So with that, I think we're ready, and I will now turn it over to Mike Ginsberg.
Well, thank you very much. And before we get started here, and I do have a number of things I want to say before we jump to the first slide, so please back up just this slide here. One more back if you don't mind. Yeah, okay, that's perfect. The weather is a little bit choppy, and I want to make sure everybody understands that. As I was listening to, I think that was Roshana, as I was listening to her, it was a little choppy on my end. So please bear with us. They are experiencing thunderstorms, lightning storms, and if it gets choppier, we'll obviously stay on top of it. Hopefully everybody could hear me okay. If not, please use your chat box here and just let people know that it's not coming in well, and we'll try to do our best. A special thank you to Ontario Systems for all of their support making this webinar possible. Shannon, Roshana from their team, and from my team, Danielle, have really worked hard here. Without them, there just wouldn't be a webinar here today. So I think it's important that we just take a moment to thank them. I certainly will. I know Rozanne will as well. We've achieved a record attendance level for this webinar. We're excited about that. We are absolutely grateful, Rozanne and myself, that you chose to spend just a portion of your afternoon with us today. Thank you very much for your time and your consideration here. Hopefully we'll be able to shed some light on some important matters affecting the ARM industry, the accounts receivable management industry. We think it's critical that we all stay apprised of what's going on. And what you see in front of you here, which I just want to dwell on for one moment, is a question slide. Very important. Rozanne and I, we talk a lot to each other, but we're not here to talk just to each other and talk about this. We want to interact with all of you. So please submit your questions. If we don't get to them today, you have our assurance that we will absolutely respond to each question that's received. So by all means, ask away, fire away, and we will respond as quickly as we possibly can. Let's get started here. Go to the next slide. Two slides. By far the hottest topic right now in the U.S. accounts receivable management industry is the notorious Department of Education contract. This is a broad topic. It's a far-reaching topic. It has a lot of implications. What I'm going to try to do is just summarize what's going on and where we are with the contract, what can we expect. Rozanne and I are also going to talk about some of the lessons that have been learned as a result of this extenuating process here that's really impacting virtually everybody in the industry. Most of us know by now that last month, 5 of the top performing agencies were terminated from the ED contract after ED claimed that they made, quote, materially inaccurate representations to, quote, struggling borrowers. They alleged further that the contractors provided the borrowers with, quote, inaccurate information at unacceptably high rates about the benefits of rehabilitation that allow borrowers to get their loans out of default. When I was able to talk to some folks offline about this, I was told that the officials, really only reviewed a number of calls, around 100 calls, out of a pool of millions and millions of calls. So unfortunately, their sample pool was extremely limited. 4 of the terminated contractors, as most of us know already, have filed suit in the U.S. Court of Federal Claims. This isn't going to be pretty as they protest the process that led to their termination. But let's go beyond that. The timing of the termination itself is by no means coincidental. The announcement came as the Department of Ed has faced growing criticism for its oversight of the various federal contractors who manage its $750 billion portfolio of student loans. With an amount of that magnitude, it's really no surprise that it gets the kind of attention that it's gotten, but it's also gotten the attention of consumer groups and some Democratic lawmakers, as well as the agency's own Inspector General, who have taken ED officials to task for not doing enough to monitor these contracts. By a show of hands, I just want to ask how many of you have ever walked through a student loan agency that services the U.S. Department of Ed, or even taken the time to listen to some of these recordings? I know Rozanne has, I certainly have, and I'm not making light of a matter here. Obviously we're on the phone, and I can't see how many of you actually put up your hand, but I know quite a number of you service the Department of Ed either directly through a contract or indirectly through having the contract on a subcontractor basis. And having the benefit of walking through one of these operations and listening to a number of these recordings myself, I could tell you that they themselves heavily scrutinize their every move. They're constantly on guard. And I sit here and I kind of scratch my head and say, are you really taking the time, or are you making a knee-jerk reaction to something that's a political fireball? And unfortunately, I err on the side of it being a political fireball. Ed said that they'll reassign accounts to these, by these agencies to others in the pool, but as of now, this has not yet happened. The small contract was awarded back in October of 2014. The small contract historically was awarded basically concurrently with the unrestricted contract. But best indications are this contract is currently being handled separately. At least it's being handled separately for now. I don't know that this will continue to happen, meaning first placements from that contract were expected to be deployed in the next couple of months. But you look at this and you say, well, what's going on with the unrestricted contract, the potential for litigation that's out there? All indications are that's going to be delayed as well. The procurement for the new unrestricted contract is still ongoing. Funny aside, and not so funny actually, 2 of the agencies that got terminated were awarded the small agency contract. The government truly works in mysterious ways, so hopefully all of this will work itself out and we'll be able to make sense of it all in the coming months. I'd like to point the bulk of the student loan lending market. I'd like to point out something that I think is really, really important. The bulk of the student loan lending market was being managed by banks, specialized private lenders, and a few large state guarantee agencies with their own student loan programs. Sometime in the past 10 years, Congress changed the laws and ended the program that allowed these private lenders to be competitive in making private student loans with the federal back guarantee. It's not coincidental with when this happened, the student loan bubble really started, the student loan debt bubble really started expanding. So where is all of this heading? I don't think that the student loan contractors, those that have these Department of Ed contracts, will become extinct. The debt load is just too staggering. Some extremists are projecting that student debt will triple over the next decade to as much as $3.3 trillion by 2024 as college costs continue to escalate to a point where students have significant debt burdens before they ever enter the workforce at compensation levels that just don't allow them to get out from under. The power behind collecting student loans will lessen. I believe that strongly. The White House is studying new bankruptcy options right now for student loan borrowers. Current U.S. law largely prohibits federal private loans from being discharged in bankruptcy, but those are subject to change in the foreseeable future. Uncertainty over the unrestricted contract that has still not been awarded, and the Department of Treasury's implementation of in-house collection services has many agencies nervous about the future of student loans. Remember, this does not only infect the incumbent agencies. There are a lot of folks out there that are going to be affected by these changes. There are a couple of dozen agencies that have made it to phase 2 of the procurement process that are dedicating significant amount of time and resources towards this uncertainty, not to mention the numerous subcontractors that have benefited from this contract. There are also real concerns that the student loan forgiveness under President Obama's pay-as-you-earn pay policy will shrink this market. A lot to pay particular attention to. This contract has a lot of history. It has been regarded as the plum contract in the collection industry because of it being a government contract, and unlike other sectors like in the banking and telecom arena, it had a true term and it defined placement volumes initially. It also had performance-driven meaning stronger participants always did well financially. Even those who were not performing as well were able to perform well and actually make money on the contract also. The terms of the contract have changed over the years, but that never prevented the participants, especially the top performers, from doing well. It seems that during this recent contract that Ed would allow you to believe that they operated alone without the influence of the FTC or CFPB, but clearly in the recent months, we don't think that's the case anymore. Rozanne, you and I could dedicate an entire webinar to this particular topic, but I'm going to shift it over to you just for a moment here. Maybe you could explore some of the lessons that have been learned as a result of this contract.
Certainly, Mike, thank you. And I think it may be too soon to call, considering the fact that litigation is ongoing in terms of any final lessons. But what I have observed and what I think might apply to anyone listening to this call, regardless of their the market segment they serve, is the fact that just take a step back. When you onboard any client, I think this whole business with the student loan contract calls for due diligence when you onboard any client. What are they asking you to do, and how do you audit and ensure that you are complying with their expectations? The next question is, are there expectations in compliance with the law? So whether it's the Department of Ed or Hospital B, the question is, are their expectations reasonable and in compliance, with consumer financial laws? I say this because I think that sometimes with the thrill of the hunt, you can onboard someone and overlook the steps your compliance officer really needs to take to ensure that the expectations of the contract are reasonable and in compliance with the law.
Rozanne,
also, yes.
And just before you move on to the next point, because I know you're going to make another point, I'll tell you what's unfair is you could do all the things you just described, and I think virtually everybody on the phone call would attest that they do that. But then the cards change, and the rules change mid-stride, and you think that you're adhering to the policies and procedures that are laid out in front of you, only to find out that you're not. And then the rug is pulled out completely underneath you, as I think what has happened here with these 5 agencies that have gotten the contract terminated, and for really, as they kind of look back, bewilderment. They really don't understand. They're now learning why. But these are agencies that have continuously performed well, have operated in a compliant environment, and they think that they were operating, towards the rulers of the game, only to have the rules change right out from underneath them.
I agree with that, and then actually that's a perfect comment, because I'm not really speaking in terms of these particular contractors at all. I'm speaking generally.
But probably worse.
Extrapolating. Well, anyway, my point is that during the term of the relationship, due diligence must continue. And as far as I'm concerned, the vendor or the party that hires the collection agency has a responsibility to communicate and oversee and review literally the collection expectations as you go through the contract in any relationship. So I just really hate to see this end up the way it's kind of being played out in the press, because I feel like the vendor, the creditor, the contractor has a responsibility in this as well. And the only other thing I thought I'd mention in terms of lessons learned or observations was really kind of a plug for people attending this webinar this afternoon. One of the requirements in the CFPB's examination manual is in the section CMR page 4, the October 2012 edition. The CFPB, when it does conduct its examination, is required, as it states in paragraphs 10 and 11, that they need to look at what is the collection agency or the debt purchaser or the collection law firm doing to maintain compliance with changes in regulations, changes in laws, changes in markets, changes in technology, and other trends. And what I'm saying is here is definitely a plug. If you are attending today, make note of this, consider this part of your due diligence to stay abreast of changes in legal trends, regulatory trends, etc.
Excellent points, Rozanne. I truly believe that you've put out there for folks to really understand what are the most important lessons to learn. One more before we move on to the next slide here, which is, from an operational standpoint, if you own and operate a business in a service business, like an accounts receivable management business that services the U.S. Department of Ed, these businesses, many of these businesses, suffer from client concentration, meaning percentage of their revenue far exceeds 20 or 25% on an annual basis, which starts to raise the concern level of lenders, investors, owners, operators, because of the reliance on that particular client. Now, the good news is this client, Department of Ed, was the plum client in the industry. Everybody desired to service this contract. Most folks did extremely well on this contract. They continued to work the contract. But really the lesson learned is when you start to see concentration levels rising up above 20, 25, 30%, many folks who have this contract have 40, 50, 60, 70, or even more percent of their revenue and a disproportionately higher percentage of their profit coming from this contract. When you start to see that happen, recognize that you're at business risk and treat the client. Certainly you want to continue to service the client, but do your best to diversify that risk among a larger base of clients if at all possible. I know it's easier said than done. It's very hard. It's also easier to focus where the getting is good, like a contract like this, but then all of a sudden you're left without the contract as to no fault of your own, and you have to move on and make determinations as to how to support the business. I think it's best to do both. Operate the contract, continue to work the business, and continue to make the investments, both financial and operational, in diversification. Let's move on to the next topic. Like I said before, Rozanne, you and I could spend hours on this topic alone.
Hey, Mike, before we go on, there's a question that's come in. I didn't know if you wanted to expand on this at this point, but the question from one of the participants says, wouldn't this be where agency and vendor audits would come into play?
I would think so. I would definitely think so, and I'm not sure how in which sense that you mean it, but I think that the vendor has, the contractor in this case, the Department of Ed, has the responsibility to engage in those kinds of audits and to adjust accordingly. I mean, right now, I'm sure everyone realizes this now. The new ball game is not hire a collection agency, Mr. Creditor, Department of Ed, fill in the blank, and thereby disavow yourself of responsibility. In fact, the responsibility for compliance and other contract terms is shifting directly to the hiring body. You know, it's a game changer. It's a complete game changer from the early 2000s and prior to that. So, yeah, it does go to vendor audits. Absolutely.
There are two more questions. Do you guys want to vet them at this point? They're on this particular topic.
Go ahead.
I think we need to move forward here and talk about other topics as well. So we will look at these offline and try and get back to them during the course of this conversation.
Great. Okay. I'll put them on hold. Thank you.
Okay. All right. We're going to move into some major regulatory news. Let's go to the next slide, Rashana. This should not be newsworthy. The fact that the state of New York has issued new collection requirements, but I thought that we would be a bit remiss if we didn't highlight some of the requirements. I'm also going to raise some news pertaining to collection requirements in the state of Massachusetts as they relate to trust accounts, and then also with our friends in West Virginia recently passed some new collection requirements. But let's focus quickly on the state of New York. Effective March 3rd, a number of new collection requirements went into effect. Another set will go into effect on August 1st regarding debt substantiation requirements. But let's focus first on what has already gone into effect on March 3rd. And basically, the state of New York, for purposes of interpreting these new collection requirements, has defined debt in a way that is somewhat different than we are accustomed to under the FDCPA. And it matters because if you're not collecting debt as defined by the state of New York in this context, then these requirements do not apply to your organization. And the new definition makes clear that the requirements are not applicable to obligations where the credit was actually extended by a seller of goods or services. That could be fill in the blank. It could be a hospital, for example. So the credit was extended by a seller of goods or services exclusively for the purpose of enabling the consumer to purchase such goods or services from that seller. If that's the kind of debt we're talking about, that is considered to be excluded from the requirements of the new state of New York regs. law. So I know some people have been taken by surprise with that definition. I will tell you, as a practical matter, 50% of the organizations I talk with say, so what, we're going to apply the requirements of New York to all debts that we collect, period. Others are segregating healthcare debt. Others are looking very carefully at these kinds of purchase money transactions. So another requirement that I'd like to just highlight is that there are new initial disclosure requirements, kind of like in the validation notice context. Language that you have to include in your notices that addresses abusive practices in the sense that they are prohibited, and the types of income that may be protected from collection activity over time. Believe me, you need to look at the law itself to understand the full extent of these new disclosure requirements, but they do impact your validation letter. And there's also a new itemization requirement that must be included in that notice as well, that initial disclosure. Also, the state of New York has created a bit of a mess for us in the sense that its own disclosure requirements concerning out-of-statute debt actually conflicts with the city of New York's out-of-statute debt requirements. We're hoping to see some reconciliation between the state of New York requirements and the city of New York's collection requirements in the near future, but at this point it is a bit of a catch-22 for compliance professionals who are trying to draft the appropriate letters. And basically what it comes down to from the New York, state of New York standpoint, you need to first of all have reasonable procedures in place to be able to even determine when the statute of limitations may expire on a particular debt. So look for that, number one, in your policy and procedure guides. Number two, look to your technology to see if that is a way for you to help make the determination and satisfy the reasonable procedure requirements. And then you need to provide a certain notice to the consumers in New York on debts that may have expired, where the statute may have expired. It doesn't say for debts where the statute of limitations has expired. So that's we always hate the word may in the world of debt collection. It has to do with what it means and what it doesn't mean, but in this case, it always creates confusion. I mean, anyway. So the lawyers on the call know what I mean. Number four, there's also a new requirement to confirm in writing a debt payment agreement or in another any other medium that reflects the way the payment was made. So if it's an electronic payment, there's an argument you could make for electronic communication about the fact that you entered into a debt payment agreement or an agreement to settle the debt. And then there's also a payment in full letter that you need to have in place. All of these details that I'm mentioning are weigh heavily in your success in terms of compliance depends on the nuances of the law itself, but I just want you to be aware of it. And then, as I mentioned, a couple of upcoming requirements will be the debt substantiation requirement that really could turn debt collection on its head in the state of New York. You really need substantiation at the outset of the collection process. And then there are very specific requirements in terms of email communications with consumers. A couple of general thoughts about this. First of all, the email communication requirements as identified by the state of New York in these requirements do not exactly mirror the Electronic Signatures and Global Commerce Act. In other words, for those of you who bear responsibility for interpreting the law and applying it to your organizations, make sure that you realize that New York did not parrot or mirror that e-signature law. And you will need to reconcile how you meet both standards if you communicate electronically, or by email with consumers in New York. Moving on to West Virginia, this law takes effect on June 12th. It A couple of the highlights include it places some limitations on the number of calls to a person that you can make in connection with collection of the debt. So, for example, it limits calls to a person to 30 or fewer calls per week or 10 telephone conversations with a person per week. Notice this is with a person. I get nervous when I see the word person in statutes, and the reason is because so many of you control or restrict calls based on an account, per creditor, but you don't necessarily have a holistic approach towards calls to a person across the board. And so we're going to have to dig into that to find out just how stringent this requirement, or how strict they are going to be in terms of interpretation when they talk about 30 or fewer calls to a person per week or telephone conversations with a person. They also modified their West Virginia requirements pertaining to skip tracing to basically conform to the FDCPA. They doubled late fees that creditors may charge on delinquent accounts from $15 to $30. And they changed the definition of communication a bit for purposes of interpreting their statute overall. In the prior to this amendment, they referred to placement of telephone calls when they were talking about maximum numbers of calls or initiating communications. It was based on placement of calls. So everybody's wondering, you know, what does that mean? Well, now they've replaced it with some lovely language, engaging any person in a telephone conversation. So does that mean I say hello and you say nothing? Is that a conversation? I guess we'll find that out in the courts. But the idea is, I think they're trying to suggest that these limitations apply to an exchange between the agency or the debt buyer and the party obligated to pay. In Massachusetts, we have a very strange issue that surfaced, not because of a change in the law, but because of a change in the way they are auditing to the trust account requirements. And I wouldn't call this a, you know, hang up the phone and run to your accounting department kind of issue. It's not that pressing, but it is something that you all need to be aware of. Generally speaking, and certainly in Massachusetts, there's a prohibition against the commingling of money in a trust account. And what they want you to do is not commingle or mix or, you know, combine money that is held in trust for the benefit of a client or clients with other money. For example, the collection agency's money, operating capital, if you will. And what we've found out quite by accident, for purposes of the company involved, one of the examiners decided, well, you know, I see that you have an obligation to pay your client A based on the total amount of collections you received in a particular month, like the gross remit number. And so yes, you can take your percentage, but then send us the other. I'll just make it up. Send us the other 2/3. You know, we should be so lucky. But anyway, send us our 2/3. You keep your 1/3. Well, anyway, based on gross dollars remitted. Well, the problem is that in some instances, certain checks, for example, don't necessarily clear as of the date that the check is issued. And so in order, when we're talking about high volume collections, if there is not enough money in that trust account to actually support the check that's being paid to the client, the collection agency sometimes would take monies from its own coffers, deposit it into the trust account so that that check clears, and then reconcile it the next month after all the other, you know, the consumer's checks clear. Well, anyway, the state didn't like that at all and considered that to be an illegal commingling of funds. So I wanted to bring that to people's attention. They need to check the Massachusetts trust account requirements. Feel free to communicate with the state of Massachusetts if you have more questions, or feel free to contact me at a later time, or of course your own independent legal counsel. Next slide. I'm kind of reading the question, but I might have to hold off on the question that someone submitted about the state of New York and working with debt settlement companies. May have to hold off on that until the last few minutes, and I'll have a chance to collect my thoughts when we turn this over to Mike in a few minutes. So let's talk briefly about 501R requirements. First of all, if you collect for hospitals, and in particular nonprofit hospitals, you should know the 501R requirements pretty much just like you know the Fair Debt Collection Practices Act, because it does impact billing and collection activity. The IRS finally came out with the final rules, I think it was December 29th of this year, with the final rules under 501R, and this is the section of the Internal Revenue Code that delineates the requirements a nonprofit hospital organization must meet in order to maintain nonprofit status. So a lot of times at the end of this, you'll either be thinking or you'll want to ask, all right, so what happens if we screw it up and we don't properly comply with 501R? At this juncture, I'm going to say our focus is the hospital may lose its nonprofit status, which is a big deal to the hospital. Let's hold off a little bit on what it means for you as someone servicing the debt of that hospital. So very briefly, the overall requirements of 501R when it comes to collection activity has an awful lot to do with this concept of extraordinary collection activity. And what this new regulation provides, among other things, I'm only focusing on a very narrow part of it right now for purposes of this webinar. I have a longer presentation I'm happy to share with any of you if you just plain want it at a later date. You can use it to train yourself or train your client, as far as I'm concerned. I don't care. But anyway, right now I'm focusing on this whole business of extraordinary, or concept of extraordinary collection activities, ECA. And what this means is the 501R is basically saying to nonprofit hospitals, okay, nonprofit hospital, you have all these patients coming through. You have a duty to come up with a financial assistance plan and to basically tell everybody and their brother who walks through your doors about this financial assistance plan. And you have to be patient and wait and include an oral communication as well as several written communications to your patients, reminding them that you have this financial assistance plan. There are even some primary language requirements. I think it has to do with the percentage of people, non-English people, speaking people you serve. So I think if it's 5% of the population, you may have to have a your financial assistance plan as the hospital may have to be translated for that group. But anyway, that is neither here nor there. The whole point is that the hospital must provide their patients with this information. And part of the financial assistance plan recognizes that for the first 120 days after the patient, after the date of the bill following the patient's discharge from the hospital. So the patient is discharged, and when the bill is sent, the hospital can begin to count 120 days from the date that bill is sent to that discharged patient. And during that 120-day period, and just bear with me, and for another 120-day period after that for a total of 240, but for that first 120-day period, the patient has an opportunity to apply for financial assistance protection. During that first 120-day period, the hospital may retain a collection agency, for example, to engage in collection activity, but they can't engage in extraordinary collection activity. And the extraordinary collection activity basically means any collection activity that smacks of a judicial process, like exercising lien rights, garnishing wages, filing a lawsuit, foreclosing on property, repossessing property, credit reporting, considered extraordinary on the obligation, or the sale of that medical debt. Again, you always have to go to the statute or the reg to use that as your authority, but I'm giving you the story behind this. So any of this kind of what seems to be a little bit more legal in nature falls into the category of an extraordinary collection activity. So let's say everybody's fine. We're giving out notices till we're blue in the face. We're reminding patients orally that they can fill out this financial assistance plan, and the 120-day period runs. Well, the reg tells us that 30 days at the end of the 120-day period, the hospital may, and through its agent, begin to engage in extraordinary collection activities, but it has to right to the patient and give them 30-day heads up that, by the way, we are going to engage in extraordinary collection activities on your account. Now, the consumer still has the right, remember I said there's that 120-day application period followed by another 120-day application period. The patient still has the right to fill out a financial assistance plan application and have it reviewed. The only difference is that once let's just say the 120 days expires with, let's say at the 90-day point or later, let's say the hospital does it consecutively, then the hospital sends out, by the way, Mr. Patient, we're now going to engage in extraordinary collection activities. Okay, now they tell the collection agency, okay, credit report, file a lien, do what it takes, let's just move on with collecting this account using some of these extraordinary collection activities beyond writing a letter or calling the person on the phone. Okay, so now let's say the patient says, you know, all right, maybe I do qualify, or maybe I would like to know if I qualify for financial assistance. And then, surprise, they file their application, and a nonprofit hospital's team of people that is very specific requirement about who looks at these applications, the people decide, you know, Bob does qualify for a financial assistance plan. Call the collection agency, tell them to stop the extraordinary collection activities, return any monies that we received in excess of what we would have received had we known Bob wasn't subject to our financial assistance plan. And by the way, put Bob in the same place he would have been if we had never begun any extraordinary collection activities. So unravel his credit report. I'll go to an extreme, dismiss the lawsuit, basically unravel everything and get Bob back into the place he should have been if we had known that he would qualify for our plan. So as you can see, there are some magic dates. It gets easier the more you talk about it, but it is very important for those of you who collect for nonprofit hospitals. And now I will tell you, what is the penalty to you if you don't comply? It probably has nothing to do with the IRS. However, in this day and age of heightened concern over patients, treating patients/consumers fairly, you will likely be subject to a lawsuit under the Fair Debt Collection Practices Act for engaging in some sort of a deceptive or unfair practice, and under UDAP for the same reason. So there is cause for concern for you to work in tandem with your nonprofit hospital clients to make sure you know all the trigger dates and that you both have this down pat. Next one. I better pick up the pace. New rules for credit reporting. At the outset, I will say this. I'll give you my conclusion first. And maybe at another time, or as we send these slides out to you, I can give you more information about it. But make no mistake, credit reporting, as far as I'm concerned, is not the favored child, so to speak, of the Consumer Financial Protection Bureau. And it could not, I'm just releasing a blog this week talking about all the telltale signs why I conclude this, but the long and short of it is that they are obsessed with the fact that they want to clean up credit reporting, hold people's feet to the fire with regard to policies and procedures to make sure that the information you're reporting is not only accurate and complete, but that it's about the correct person. And they seem to not favor, in my opinion, data furnishers. The collection agency is serving as the data furnisher, as much as they may favor the credit grantor, the party that holds all right, title, and interest to the debt, to be the data furnisher. So I guess this must suffice it to say there is, for purposes of your takeaway from this webinar, you need to be very aware of the National Consumer Assistance Plan that came out recently as a result of a collaborative effort between the State Attorney General for the state of New York and the big three credit reporting agencies, TransUnion, Equifax, and Experian. And it really provides there are some very, very detailed requirements that are coming out in this National Consumer Assistance Plan. Again, you can reach out to me for more detail, but if anybody, by the way, is using Metro 1 format, that's no longer going to work. And the other point I'd make on this slide, which I would love to talk about, but no one seems to be as upset as I am about a consent order that came out in November. I think it's November 19th, between the CFPB and a company called DriveTime. But if you want to read and learn about what the CFPB expects in terms of credit reporting, read the DriveTime consent order. You can find it online by just Googling what I just said. Next slide. Medical debt collection requirements. You know, when the CFPB first came into being, so to speak, and opened its stores in 2011, and then in 2012 gave us the definition of larger market participants, we all took note of the fact that the definition of larger market participant included, the calculation is based on whether you earn more than $10 million in fees from collection activity per year, going back 2 years, I think, maybe 3, but excluding fees received from the collection of medical debt. But last September, the National Consumer Law Center came out of the woodwork in a very big way, urging the CFPB to change the definition or the calculation for larger market participants and include medical debt collection in that calculation. They want medical debt, this consumer group and others want medical debt to become part of the fabric of the CFPB supervisory role. And I am not going to be surprised if when we see the final proposed or the proposed rules from the CFPB either in 15 or 16, I won't be surprised to see if they do change the definition of larger market participant to include medical debt. What will that mean? It means people that collect medical debt will be subject to the supervision of the CFPB if their fee revenue hits that over 10 million mark. Also, this doesn't help the cause. Complaints regarding medical debt alone hit 20%, 20 point something in January of this year, 20% of all complaints filed. So really take notice of that. Your hospitals are going to start to ask you, if they haven't already, more and more about the FUD surrounding the CFPB's sniffing around the whole medical collection industry. So beware. Next slide. Envelopes. I'm not going to go through the court cases. I think all of you know that if a window envelope used in connection with the collection of the debt permits the viewing of an account number or anything having to do with the account or the consumer, etc., and that can be seen through the window, it seems to turn into a call or a lawsuit from a consumer. These cases all surfaced about in September. Recently, a judge in Illinois said, this is Poppycock. I'm throwing this case out before it even gained any. I don't even think it had been filed 24 hours, and the judge threw it out saying, this is ridiculous. I'm done with these stupid envelope cases. But that issue is alive and well. That my defense lawyer friends tell me, you know, really, everyone should stop worrying about it. Just take any information out of the stupid window envelope and let's put this one to bed. So the issue is still there. They're usually going to get you on one-off single cases here and there just because they're easy. It's like easy picking. Next one. Next one. Okay, turn it over to Mike. Thank you.
Rozanne, thank you. And everybody submit your questions. I know you've been firing away, but Rozanne, when she's in mid-stride and really elaborating on some of these points, it's very hard to get off course and focus in on the questions. She's going to start to do that now, and she might pick one or two, as you said earlier, that she'll address going forward. So, you know, Rozanne, did they say Poppycock up New York? I don't think they use that expression in New York.
Well, we say pop and poppycock.
I got to remember that the next time I'm walking through the streets of Manhattan to try and use that expression. I think it will come in handy, especially on the subways. Okay, switching gears here to a topic that tends to be on the mind of most owner-operators in this business, and we have a number of them on this call. We also have a number of investors on this call who have put money to work in this industry as well. We're going to focus in. Please go to the next slide. M&A pricing. Those who have worked with me in the past have seen this snapshot. It does change quite a bit, so I'd like to focus in on some of the details over here. But before doing so, let me emphasize that in 2014, buyers continued their acquisitive ways, completing more transactions in a one-year period of time than at any other point since the start of the Great Recession. So prior to the Great Recession, we saw a buildup in the number of acquisitions that were taking place in the U.S. accounts receivable management arena. That slowed down for a lot of reasons: performance, availability of capital. It certainly resurfaced in a number of different market segments, but the market catalysts of years prior, bank card, credit card specifically, have not driven the kinds of acquisitions that we have seen in recent years. We expect that this trend of number of deals is going to really continue to accelerate for a lot of reasons. Actually get into all of this in a recent report that we put together where we review the aspects of the industry. We're going to be releasing that shortly, but for the purposes of this presentation today, I wanted to focus in on the M&A pricing and give you just a snapshot of what's going on, why we think this is the case here. Take a look at this. This is for 2014. I think the same trends do apply here in 2015 as well, but it gives you a sense on how businesses are being priced, small on up to our definition of platform. In this industry, companies over 100 million in revenue. It's very important that you understand something. These size requirements, or these size parameters, let's say, are not the only driving force on what defines the value range and ultimately the multiple that's applied to these service companies. It's a category. It certainly matters, but it's not the only category, and it's not the only one that matters. A lot of folks look at other components of the business where they gauge value. Most specifically, they look at the client base and the type of clients that are being serviced. They also look at the management team and the ability of that management team to continue to operate and lead post-transaction. They look at other components as well. The growth, is it sustainable growth, or is it a flash-in-the-pan growth that they could punch holes in and kind of say, well, you know, it's great now, but I don't know if this business is going to be there a year or two from now. There's some definitions here. SDE. I'm not going to read these off the slide. You'll see these here. But for the smaller businesses, the vast majority of the profits that ultimately a buyer is going to assign the multiple to come in the form of sellers' discretionary earnings, usually tied mostly to their and their partner's compensation. As they get larger, we look at obviously at EBITDA and adjust it and normalize it to pull out any extraordinarily high one-time expenses, such as a move, for example, or excess operating expenses like the payout of a previous partner or something to that effect. So when you look at these, there's always going to be outliers, those that kind of throw off the range. But these ranges should give you some guidance on current approaches to valuation. please keep in mind, and I've had arguments with ACA over the years and other groups and associations who try to, no knock on the ACA, but trying to shortcut valuation of these enterprises. It's very difficult because there truly are no hard set rules of thumb when it comes time to valuing an ARM company. So these ranges give you a good indication of where to start, and that's what we're trying to do here, give you a starting point. Every business applies differently, so I am going to cover a number of points here that I'd like for you to consider when you attempt to determine the value of your own operation or an acquisition that you might be contemplating in this industry. First, transactions that include little or no cash. The left end of this range when you start talking about smaller and mid-sized players, and even sometimes the larger players, you don't see it as much on the platform companies. But transactions that include little or no cash at closing are typically defined as mergers among industry players, and they don't really apply to outright sales or purchases unless the seller is not operating profitably or that company has severe performance issues. Second, most small ARM companies have owners, either one or maybe a couple of folks, who have major client relationships and are really involved in virtually all facets of the business. What you start to see when you get to mid-size and certainly larger businesses, they start to develop a farm team concept. You start to see bench strength in the organization at various components of the business, and you start to see that the client relationships and really the involvement in overall operations tend to be spread over multiple people. That's not always the case, okay? And that's why this rule certainly also applies to mid-sized companies. But the rule is significant value really is realized when those relationships are transferable under the sale of a business. So if those relationships are held tight with one individual that's going to go away shortly after the transaction is completed, that's going to be really the value and ultimately the deal structure is going to be driven by that component. But if you could remove that or reduce it by having a number of people within the organization, or for that matter, the organization itself service the clients after some period of time. So the salespeople are out selling and the ops people are operating the business, and there's a true separation. So when there's a problem, they actually call someone within the operation, hopefully someone other than the owner-operator. They call someone within management. Well, then the transferability of that business goes way up. Okay, so let me emphasize the point and say where there's a situation where where a small or mid-sized player have client relationships with one person, that may very well diminish the value and increase the structure, i.e. less cash. Third point, higher levels of cash tend to drive lower multiples overall, especially for smaller and sometimes mid-sized transactions, certainly for underperforming companies. But this is typically not the case. For larger companies and platform companies, you tend to see more cash at time of closing, and that does not at all negatively impact the value that's placed on those enterprises. Fourth point, healthcare and government services, not Department of Ed, as we talked about earlier necessarily, although I do think that that will rebound nicely and continue to create value for those shareholders. When I say government, I'm talking about state and local, i.e. municipality level governments. Those are the ones that are currently generating higher prices and more favorable deal terms on average than financial services and telecommunication market segments. 5, in those instances when severe client concentration exists, less cash is typically paid at closing and more is paid out over some period of time based on the retention of those key clients. Exceptions absolutely exist with this particular point, and they take place when the client is difficult to penetrate on their own and or that client is locked into a long-term contract You tend to see that at the state and local levels. You tend to sometimes see that with some of the larger clients as well. And if there's true terms within those contracts, and those contracts are transferable under ownership change, then in those instances, the buyer feels a lot more comfortable in the stability of that business and may forego the terms and be willing to pay more cash. The last point that I want to make on this slide, which I think is very important, this is specifically tying towards service providers, the companies that are more people intensive. When you start looking at businesses that are technology vendors and or debt buyers that have assets under management, i.e. the portfolios, those types of companies are valued significantly differently than these that are valued on a more ongoing concern. There's different multiples. There's different components that are looked at. They are just valued differently. Let's leave it at that. If you want to talk offline about how your company might apply, absolutely we'll have that conversation. But please walk away knowing that this is for service companies, this snapshot that you see in front of you. And debt buyers and tech vendors would absolutely be valued differently. The other thought that I want to leave you with is this industry, in light of the regulatory climate, which is intense, okay, and changing, very dynamic, is attracting considerable attention right now, not only from inside the industry, folks who are looking to expand through acquisition, but a number of different folks from outside the industry, financial investors that are looking to put money to work, that like this industry, looking to back the right leadership teams because they're not going to do it themselves, and companies from related industries that are looking to enter this marketplace for the very first time. Let's move over to the next slide, please. Rozanne, back to you about TCPA.
Mike, I'm just checking to see if any questions came in for your part.
And I'll do the same. I'll do the same as well. But go ahead, and
okay.
I can inject them just to keep this moving forward.
Okay. Well, just following up on a couple of questions that did come in. One person asked a very detailed question about the applicability of the New York requirements to the collection of debt when a debt settlement company is involved. I would have to give that more thought. Again, it's really not, the law doesn't really concern itself so much with who you're talking to. It's whether the debt subjects you to compliance with the state law requirements. And I would also say, just because of the cases we are seeing in other areas, that even lawyers need to be provided with the protections of the FDCPA. I would say that you might as well apply the New York requirements to any debt you are collecting, even when you're working with a debt settlement company. That's just my opinion off the top of my head, but consult with your own legal counsel. So let's talk a little bit about the TCPA. We are seeing some tremendously high settlement numbers when it comes to TCPA settlements. I mean, this is, the TCPA, I mean, it is far beyond the collection industry in terms of its impact. Just a few of the recent decisions and settlements, I mean, we're talking about in Illinois, a federal judge just approved a TCPA settlement with the bank HSBO for $40 million. That was the third largest settlement. Cap 1 several weeks ago, a settlement was approved also by the same judge in Illinois for $75 million. We know firsthand of a healthcare collection agency that just settled a TCPA lawsuit for $2.75 million. And we know that even the likes of Twitter, with all the financial resources and probably the legion of attorneys they had to go to bat for them, they were unsuccessful in convincing the court that they you know, it's kind of like, we're sorry, we accidentally communicated and sent a text message to a person for which, you know, we had consent from them once, but because their cell number no longer attaches to them, we made a mistake and accidentally communicated with someone who we did not have consent to communicate with. And the judge said, you know, and Twitter said, well, isn't that I'm picking on Verizon and Sprint. I mean, it doesn't, isn't that Verizon's fault? Isn't that Sprint's fault for reassigning that number to another consumer? I mean, Bob already told us we could communicate with him via his cell phone at this number. We had consent, and the judge said, kind of like Crimea River, I don't care. The law does not permit you to communicate with someone by way of their cell phone for which you do not have their express consent. I'm sorry, the number was reassigned. As far as we're concerned, use Newstar. Use some scrubbing service that gives you a high correlation between the likelihood that this number is associated with a particular consumer. So that's the big news there. Another one, American Express tried to convince the court that, you know, we did hire a collection agency to help us, but, you know, we didn't actually place the calls to the consumer, so we don't really think we should be responsible for this. And the judge said, well, I'll say it, Poppycock. He said, no. You are liable for calls you did not even make. You hired a debt collector. You are responsible for the calls that debt collector placed. Since those calls were placed to consumers for which you did not have consent and you used an auto dialer, therefore you are liable. So this has really created a place to target right on the creditors themselves. There's a recent case, Jenkins versus National Grid, where the plaintiffs just skipped over the collection agency altogether and went right for the jugular. They went right for the creditor with their TCPA claims. So doesn't mean collection agencies have nothing to worry about. It just simply is a bit of a trend that we're seeing. Next slide. Next one. Mike?
Yeah, the end of an era. Thanks, Rozanne. It's not often that an era comes to an end in anything. If you're a sports fan, end of an era could be the retirement of a player, like last year as a Yankee fan I experienced Derek Jeter retiring. That's an end of an era. Mariano Rivera the year before. It's the end of an era. Sports definitely have eras defined to it, but a lot of times industries don't. This one certainly did, and I want to highlight an event on today's call that you can all kind of earmark as the end of a particular era. When Accounts Control Technology, ACT, announced the acquisition of Convergent Resources, CRI, late last year, it marked the end of a defining era in the U.S. accounts receivable management industry. And that era was the end of the roll-up or the consolidator strategy that really took hold in this industry in the 90s and into 2000, around 2004, 2005. We really saw it, and then it kind of moved forward into the early turn of the century as well, 2005, up until later on. But a number of these conglomerates were really formed, and they were influenced by private equity in the marketplace at the time. We remember some of the names, some of the roll-ups that took place and started forming in the mid-90s, 1990s. OSI, RMA, Intelliris, to get away from the acronyms and talk specific names. So you had outsourcing solutions, risk management alternatives, as well as Intelliris, now iCor. There were quite a few others. Convergent Resources was one of them. AMO was another. These companies ran really rampant through the industry for more than a decade. They bought each other. Some of them sold to each other. We saw a lot of transactions take place, among them buying small and mid-sized players. And really, as they continued to grow, what they were trying to do as quickly as possible is build up market share and really take a position in the industry of size and a position in the industry of clout that they could leverage going forward. Some moved into integrating these businesses. Others kept these acquisitions on a standalone basis. Okay? But the point that I want to make here is we really saw this as a defining time in the industry. It influenced a lot of direction. A lot of business changed hands, a lot of money changed hands, a lot of accounts turned over. But the sale of convergent resources to ACT officially marks the end of the consolidator era in the U.S. ARM industry. And I think that that's something that we should all pay particular attention to and be sure to focus in on going forward as new eras are formed. And certainly we're starting to see some of those form now. And I wanted just to point that out. Let's go to the next slide, please. Rozanne? Hello?
Okay, Mike, I apologize. I'm here.
Okay.
I was just having trouble getting.
I thought it was something on my line, but let me make one more point here as I'm just looking at my notes. It's kind of funny. I heard that Howard Stern gave a eulogy for Joan Rivers when she passed away. And he looked down at his notes, and I, as a speaker, I kind of appreciated this too. He said, you know, a couple of pages stuck together. I didn't even realize it because I got so involved in what I was talking about. Well, I just had the same dilemma here on a different scale, obviously, than Howard Stern. But I just want to make a very important point here about that era coming to an end, and that is I don't want folks to think that private equity is out of the industry altogether. That is absolutely not the case. Private equity continues to look at this industry as evidenced by, even this past year, Platinum Equity purchasing the assets of NCO. But the consolidator model of backing a leader to acquire multiple businesses quickly just to gain market share, that's not being pursued in this sector at this time. Rozanne?
Okay. Very good, Mike. All right, let's go to the next slide. For those of you who need some, if you instead of Ambien, you'd like to read something else, I suggest you print the CFPB Supervisory Highlights. It's the 7th edition. It's fascinating reading, but seriously it is. It tells us what the CFPB has been up to and what are their hot buttons, I guess. And so a couple of points I wanted to pull out from the most recent edition of the Supervisory Highlights. First of all, they made clear that the credit reporting agencies have taken another step to help us identify consumer disputes. They have created a new online portal for consumers. Now, when the consumer disputes through this portal, it's my understanding the disputes still trigger the e-Oscar dispute, but nonetheless they are trying to create an easier mechanism for the consumer to use in order to file a dispute regarding their credit report. They spend a fair amount of time in this report talking about allegations, and that's all they are, but deceptive practices that were allegedly used to collect the Department of Education debt. So I just feel like, you know, you can't ever cast stones, or there's expressions about the pot calling the kettle black or whatever it is. I mean, it doesn't take but the luck of the draw, and anyone could be in some of these situations and be the subject matter of a supervisory highlight commentary. But my point is, I just want you to be aware of what's in this and how they are so prolific when they like to highlight an issue. And when they do highlight an issue, that means it's probably important to them, and we may see regulations surrounding it. So that's really the point of my second bullet point. Third, the improper notice of the right to change an ACH recurring transaction was highlighted as a big no-no for an agency that had been examined. Apparently their policy says that consumers had 72 hours to modify, change, stop an ACH recurring transaction. I'm sure it applies to recurring debit transactions as well, but I'm using the language in the report. But the actual collectors told people, oh no, you only have, if you want to change this agreement regarding the recurring transactions, you have to tell us within 24 hours. So that discrepancy between what the policy said and what the collectors were telling people drew the attention of the CFPB. They also noted deficiencies in compliance management systems. And as you know, I opened with the comment referring you to certain pages of the examination manual, and I think, you know, it's like a lot of things. The further you get away from the source document, the less accurate your memory really is, and I think it's time for us to revisit the examination manual. I live and breathe it because of the assessment work that I do with Ontario systems, but I really think it's time for your compliance management people to go back and check, is our compliance management system truly, you know, firing on all cylinders as required? Because the CFPB felt that, for example, in this one agency, the fact that they had recently hired a chief compliance officer, plopped this person into a certain position, and this person, you know, just really didn't understand the policies or procedures and was unable to train the staff accordingly, created a problem for the CFPB. So time to revisit those requirements. Also noted, not in this report, but from another source, that the CFPB is apparently quite sensitive to call audit requirements. You know, so for many years the industry has been very prone to, yes, oh yes, we do quality assurance. We have a quality assurance program. We audit 5 calls per month per collector. Well, the catch is you have to audit for compliance with consumer financial laws when we're talking about quality assurance for the CFPB. And also, they are questioning whether 5 calls per month really tells anyone anything. And they're pushing the question, do you need to audit a statistically significant number of calls in order to make a call audit valuable or meaningful at all? Next slide. Let's go to the next slide.
Thanks, Rozanne. Please continue to submit your questions. They're very important to us. In the interest of time, we may not get to all of them. We may only get to a few more today. And Rozanne, please look at the questions and see if there's anything that you think we should answer, and feel free to throw it out if you think I should answer it and repeat it to the group. But we will get to all of your questions because they're important to us as well. Next slide, please. I'll just touch on this very, very briefly. I think this is an important indicator and worth noting here. But employment, or the unemployment rate, continues to be the most critical economic indicator for armed companies to watch and track and stay closely in tune with. Unemployment seems to be heading in the right direction. However, there's a lot of questions associated with that. We started tracking consumer confidence more closely, as this slide indicates to you, because it's a good barometer of collection performance. This one, Michigan's index, we started using it because it is widely accepted as a substitute for the College Board's Consumer Confidence Index. It's not an indicator that we've used in the past, so we're going to continue to track it. We like using it now, and we think it has some basis in this industry. What you see here is that consumer optimism slipped in early March among lower and middle income household levels, while confidence improved among households with incomes in the top third. The renewed concerns expressed by lower and middle income levels, middle income households, mainly involve income declines, higher utility costs, higher cost of just living costs, as well as disruptions to shopping and their business due to the harsh winters that many of us had. Among the income in the top third, strong gains were concentrated in the near-term outlook for the economy and for buying plans. So this kind of lays out where we think the market is headed, that upward tick on the right side. And despite the temporary setback, the overall levels of confidence remain favorable. We think this bodes well for collection agencies and accounts receivable management firms in general, since higher levels of confidence are typically a good sign that increased debt obligations by households will come on, and as well as there'll be lifts in the recovery process, i.e. collections. So this should be a good indicator of the results that we'll realize in placement volumes on a going forward basis. There are a number of other indicators, and we'll get to those in our report, which we'll have available to you shortly. Next slide, please. Rozanne, you were across the pond for a little while. Do you want to summarize in just a few minutes some of the things that you saw from across the pond?
I will, and I will do this very, very quickly because I know we have a few more slides and a few more minutes. But the reason I added this topic to our presentation today is because, we are trying to give you at least a view of the world as Mike and I see it and the issues, etc. Well, fortunately, I had the pleasure of like probably 12 meetings with collection agencies, banks, a credit reporting agency, etc. in the UK about a week and a half ago. And what I found fascinating, and the reason I was so interested was, A, to find out about the market in the UK. Like, is it a place for us to go as an industry? And I have some conclusions about that are beyond the scope of this webinar, but I thought you should know, if we think we have an unusual situation with the CFPB, just get on a plane and go to the United Kingdom. They have the FCA, the Financial Conduct Administration, and this organization is huge, like the CFPB, employs thousands upon thousands of people, extremely powerful, and it's called Financial Conduct Administration. Has direct supervision, certainly over collection agencies and debt buyers, and by all means the banks and financial institutions in Scotland, Wales, and England. And they are driven to implementing collection practices that focus solely on consumer fairness. One of their phrases is I shouldn't have said that without knowing it. I just went blank. But it's like fair collections. Oh, I know. Fair profits, fair collections. That profits will be deemed to be fair in the eyes of this FCA if the collection process was fair to the consumer. And they even go so far as to requiring, prior to a debt payment schedule arrangement, that the collection agency engage in a financial evaluation of the consumer so that they can document the likelihood of the consumer being able to sustain payments according to that schedule. So even though the consumer may say, sure, I can pay £500 a month, if in fact your financial evaluation of the person's state does not support that kind of a payment, it will be deemed unfair. So that's just a fascinating approach. If not, there may be some other words that you choose to use as well, but it is highly burdensome. The other thing I thought I would just share very, very quickly is that the market itself is about 1/5 the size of the United States. A lot of student loan debt, a lot of government debt being let now, and there is a company that has managed to find its place in the whole hierarchy where it will be the company selecting collection agencies to collect the government debt, including student loan debt. And the other point is that, in the United States, how, if you haven't heard this, I hope I'm not the first one to share it, but a lot of our banks and credit grantors, so the big guys, the big credit companies, etc., they are heavily supervised by the CFPB, and they in turn are tending to gravitate toward larger market participants when they select collection agencies and debt buyers that are also supervised directly by the CFPB, and are reducing the number of agencies that they even use to collect their debt. Well, this same phenomenon has been occurring in the UK, and what is interesting to me, the fair-haired children, so to speak, are the debt buyers in the UK, and the reason is that there is a general perception, and I trust it's a reality, that it is the leading debt buyers. Some of those debt buyers are from the US who have found their way to the UK, are considered to be the most sophisticated in terms of their technology, their infrastructure, their commitment to compliance, their training, and their general investment in compliance. And I found that to be fascinating. The debt buyer is considered a very, 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 very high on the compliance food chain in the UK. So Lots more to talk about in that area, but I will leave it at that, Mike.
Thanks, Rozanne. Next slide, please. One more. So, okay, I don't see the poll here, so I guess the poll question is not going to come up on slide 28, and that's unfortunate. We were trying to incorporate a couple of polls here, but this one's not here.
Mike, we can poll it now if you'd like.
Okay. You know what? In the interest of time, let's hold off on that.
Okay. Great.
Thank you. This is the last topic, and a topic that we thought was kind of important just to get a sense out there of where you all are spending your time, what conferences made some sense. It'd be interesting to see here. You know, I'm going to rethink that. If it's possible to do the poll quickly, let's put it out there for the folks who are still on the call.
Sure, we'll try it, and you can just keep going.
Okay, let's try to do that. Really, when you get down to it in the industry here, there's two types of conferences. There's the association conference that put on a number of levels, units on up to convention. You see it in the various conferences from NARCA to the Debt Buyers Association to, of course, ACA International. There are other types of conferences that attend as well. Our question here, let's just throw it out there. How many live events are you planning on attending in 2015? Less than 3, 3 to 7, more than 7, or maybe none at all. If less than 3 is, you know, put 0. That's great. That's less than 3, of course. So it'd be interesting for us to see this, and we'll come back to this shortly. Can you go on back to the slides?
Actually, we'll have to close the poll to do that, Mike. So the quick numbers are 64% were less than 3, 31% was 3 to 7, and 5% of more than 7.
Okay. Well, I think those numbers, thank you. I think those numbers have changed pretty dramatically in recent years. Less than 3 seems very low, especially from those who are out there sponsoring these trade shows. And why do people attend these conferences, and why do they choose not to attend these conferences? From our standpoint here, I mean, those interests and decisions vary probably from individual to individual and company to company. But I think it's a worthwhile discussion to have. Some folks attend conferences to network. Other folks attend conference hoping that they're going to get the next client or at least touch base with existing clients. Some are there to learn. Some are there to learn, and others are there to see the new vendors on the exhibit hall. Rozanne, why do you see people attending conferences, and what types of conferences are you and your group going to? I know you exhibit a lot, so if you look at it from a broader perspective, why do you think people attend conferences?
Well, I think it's changing. In the past, you know, prior to 2008, I would say that people attended conferences because they could. They were the owners, the operators, the whole industry was different then, and they were the ones that would invest the time and money to attend a conference, and it would be educational. They'd be the bearer of good or bad news back to their organization, and they'd do deals. But now, I don't see it that way. I don't see it that way at all. I think it's interesting to see the poll results because people don't have the time to be away from the office, and I think that's why sometimes people like these webinars, but I could be wrong.
And it kind of leads into the next point, which is there a better mousetrap? A number of times you go to these conferences and you're inundated by salespeople. And that's great. I mean, people have a business to drive and they have a reason for being there, but decisions aren't made and you're not necessarily getting to the end user. In fact, if it's inundated by salespeople, a lot of the end user, the decision makers within these organizations, credit grantor organizations, debt buying organizations, they may choose not even to go because they don't want to be bombarded when they walk through an exhibit hall. They want to learn, they want to experience, they also want to network, they also want to schmooze with their friends, and they're not given the opportunity to do so because they're solicited time and again from people they don't necessarily know. So I leave everybody kind of thinking about this. And I'd love to hear your thoughts if you have some. Is there a better mousetrap? Is there a better way to do this? Is there a way that works for everybody that's not cost prohibitive, that doesn't really remove the intimacy of a conference, which is face-to-face, right? And you kind of think about where you spend your time, pick and choose your battles. There are some opportunities where you get away from your desk and it gives you really a chance to think. Maybe it makes sense to have them in Vegas. The vast majority of these conferences tend to be in Vegas. Maybe it's better to remove it from Vegas and move it around a little bit so you have a little bit more of a captive audience with less distractions of the casinos and the shows. So I leave everybody thinking about, is there a better mousetrap? Is there a better way to do this? I thought this was a fun way to end some of these topics when you talk about regulation and you talk about the U.S. Department of Education. They're pretty intense topics. This is an opportunity for everybody to kind of think what it is you're looking for, and I would welcome the interaction with you folks if you have some thoughts as to where you spend your time and what kind of a mousetrap you might be looking for. Rozanne, anything else you want to add today?
No, it's been just an absolute pleasure to work with you, Mike. I hope the audience found this valuable at the at the end of this. Thank you, Shannon or Roshana. That's the contact information for the two of us. If anyone needs to reach us, please feel free to do so, and then our teams will be sending out the PowerPoint and or at least the recording, right? If you need any information, though, feel free to reach out to Mike or to me. And join us again. We do this quarterly, and if you have suggestions or questions about future topics, do not hesitate to share. Thank you so much.
Rozanne, thank you. I look down at the clock, and I'm pleased to say it's 3:31 now. We are ending pretty much right on time. Folks behind the scenes here, Shannon, Roshana, and Danielle, thank you. Thank you very much. I think you did a wonderful job today getting everything organized. And Rozanne, you are absolutely a pleasure to work with. I really enjoy our interactions here. Audience, I hope you benefited from this, and please keep us posted on things you're seeing in the marketplace, and stay tuned for the next one. Thank you all.
Thank you, Mike and Rozanne. If anyone has any questions you would like to submit for a response or feedback you'd like to provide, please send them to events@ontariosystem.com. And one final thing, please take a few minutes to complete the survey about this webinar. We value your input, and we take your feedback very seriously, and it's used in the planning of our future webinars. Thank you. Everyone have a great day.